So when there's conflicting heirs and initially they petition and trying to see who gets full authority, and then the judge makes a decision, can those heirs still come back when during the notice of proposed action to contest the probate? Like if you have your brothers and sisters and everybody's petitioning, the judge rules, okay, Bill, you got it, full authority. Can those brother sister heirs come back during the notice of proposed action time and contest again, or is it just for family members that weren't aware of the sale?
So I think we've got a couple moving parts. I think we probably need to clarify a few issues first. Being appointed the administrator or executor of the estate doesn't define who the heirs of the estate are. That's just the person that has been appointed by the court to be the one in charge of it, running it. And when they're running it, they have what's called fiduciary duties to the estate to do certain things properly, such as sell the house for fair price or sell it for top dollar. If you're going to rent a property, you need to rent it at fair market value, not to your friend down the street. So if the administrator, whoever's been appointed, if it's a sibling, a professional, a named executor, if they're not acting appropriately, the heirs of the estate certainly have claims against them for breaching their duties, fiduciary duties to the estate. If they issue a proper notice of proposed action to sell a property for fair price, and the beneficiary, the heir of the estate, misses that window of time and does not object, you kind of missed your chance to object for that particular sale. It doesn't change distribution at the end. It is not a deciding of who gets what. It's more of, I'm selling this asset, court, I want to sell this asset. I'm putting the world on notice, we're going to sell this asset for this particular dollar amount. And you have your 15-day window to raise your argument or complaint for why it's not valid. And if you miss that window of time, that asset can be sold, but it doesn't change the fact that that asset, the cash from that asset or sale, is still sitting here in the estate's account until final distribution. So you kind of had a couple different parts in there.
So if an heir was initially denied full authority by the judge, they can't come back during the notice of proposed action and contest the sale again.
Absolutely.
Contest.
They can.
No, right?
Yes, they can object, because the appointment, being denied appointment, doesn't change your status as an heir. It just means you're not the one in charge. So if two competing brothers want to be the one in charge, one's got really good credit and get bonded, the other one can't get bonded, court goes with the bondable one, that doesn't mean the other heir is now out of luck. They can't bring claims against the estate or hold the other brother accountable. You certainly still can hold them accountable for their conduct as administrator. It just doesn't mean you're the one making the decisions. You're not the one signing the listing agreement or taking it to market. The other sibling who's been appointed can take it to market. They still have to do it properly. So if they're selling it for 50% of the inventory appraisal value, object. Please object.
But they can't just like contest for arbitrary reasons, like, oh, I don't want the house sold, or I don't like my brother, or these crazy erroneous reasons that have nothing to do, irrelevant with the estate. It's just, they want to be difficult.
Yeah, they do. They'll object for whatever reason they want. Whether that objection holds up the sale or not is a different story. So they make their objections all the time, and I have to deal with angry people. But whether it stops me from selling the property for a fair price, as long as it's 90% of INA value, inventory appraisal value, the court will let you sell it. But if they're just saying, I want to be able to keep the house, well, unless it's been specifically gifted to you in a will, you're not. If you have IAE, independent authority, and the house needs to be sold, it's going to be sold. There's more often than not in probate, the property needs to be sold anyway to cover statutory fees or expenses of the estate. Almost never do you actually get to keep the property in administration.
Good. Thank you.
This one. So I think we're talking about two different cases there. One is if it's limited authority, people can object, but once they've gone through the process and go to court, the judge, in my experience, turns to them and say, well, do you want to buy it? Right. They advertised it. Here's the price. You just need a 10% deposit and it's yours. Do you want it or not? I've literally been in the court where the judge said that to the objectors, and the objectors, Well, it should sell for 30% more. Well, great. Do you want to buy it and make money on it? Well, no. Okay. And it's been for sale for 30 days. Sorry, you can't. On full authority, my experience in LA County is anybody can object. There's no proposed action filed, and the judge will schedule some process, a hearing down the road, or ask them to submit something in writing. And at least it will delay the sale for some period of time. Is that your experience in San Diego County as well?
Yeah, it can delay the sale if there is a worry of losing the buyer or the market flux is going down. You can go. I would take that opportunity for an ex parte hearing to get immediate approval of the sale. If somebody's for no particular reason objecting, if they're coming in and say, I don't like this, well, then I'm worried I'm going to lose the buyer. The buyer's going to walk and the market's gone down 10%. I think that's a valid ex parte basis to bring an ex parte claim. But
there's a reason to hire Zach right there.
Everybody, that might work for me. It might not work for the next guy.